Well, Angela, what's up? Where did this debate come from, and why are we getting, I think, a very useful history lesson,
Yes.
but talking about a law that was passed 142 years ago?
Look, I think this is coming out of the frustration with our broken immigration system. I think opponents of reform are grasping at straws and offering this radical idea, frankly, of changing the Constitution. This is settled law that if you're born here, you are a citizen. The United States is not a country club. You don't have to apply to belong. And frankly, it's what's made us the cohesive nation that we are. There is a legitimate argument about our broken immigration system, and that's the argument that I wish we would have. But unfortunately, opponents of reform are going for what's radical. This is a very heated time in Washington, so it's a pattern that we're seeing. And I think we're really, it's taking away from the discourse that we need to be having about how do we fix our broken immigration system? What do we do about the people who are here without status? What do we do about people who want to come, to be sure they come legally with a visa, not with a smuggler? But at the end of the day, I don't think that the American people want to change the Constitution. It's a problem that can be dealt with a fly swatter, not with an Uzi.
Dan Stein, you heard Angela Kelly use the word radical a couple of times. Is this a radical proposal?
Well, I also heard the word Uzi. Look, the 14th Amendment, birthright citizenship, it's a fascinating topic, interesting debate. The question of, are the proponents of change in Congress serious about doing something? Or are they just engaging in electioneer posturing is an interesting one, because my view and FAIR's view on this is, if we're going to have real reform of immigration policies, we're going to have some major structural changes in order to address perceived problems that have arisen, that have produced such a large illegal resident population in the country today. And birthright citizenship, current interpretation of the 14th Amendment, is naturally going to be an important topic for debate, because language that was drafted in 1868 at a time when 99% of the American people didn't travel more than 20 miles from their place of birth their entire lives, clearly is not working in a modern world with millions and millions of people on the move, going all over the world all the time, where you have orchestrated birth tourism tours coming in from countries like Korea, where people come here in an orchestrated way solely for the purpose of having children who get U.S. citizenship. This overt manipulation of birthright citizenship is something that is not only defeating the operation of U.S. immigration controls, it is inappropriate to post-industrial information societies around the world. Very few have these kinds of policies. Congress has always had the ability to define the phrase that you mentioned, subject to the jurisdiction thereof, so that, for example, diplomats, when they have children here, they're not considered U.S. citizens because the parents have diplomatic immunity. And the argument, in our view, has been that when someone comes here illegally, they've never actually, particularly if they enter without inspection, then they've never actually submitted themselves to U.S. jurisdiction. They haven't actually asked to come in. They haven't informed the government of their presence. The mother hasn't obtained any form of documentation associated with even having passed a port of entry. And that clearly the framers of this language did not intend the amendment to include people who had never at any point in time established a social contract, if you will, with the state. And if they've been here for 45 minutes and then have a child here, well, the fact that states still issue birth records because of our historic federalism thing, practices mean that ultimately we feel like we're kind of being taken advantage of. And so
I want to get to some of these.
Congress has the right to clarify this language. And if Congress can't clarify it, there's nothing so sacrosanct about the language of the Constitution that we can't amend it. And that's why we have a system for amending the Constitution. And we ought to do it.
And we do, but not often.
Yeah, well, it happens.
26 or 27 times in 220 years.
I don't think the framers ever thought we would amend it so infrequently. In fact, I think they'd be shocked at how infrequently we're amending the Constitution. That's such an old and archaic document. Arguably, it needs to be amended far more frequently.
Mario, there have been people who have complained about birthright citizenship for a long time, but the debate over the 14th Amendment has not had the prominence that it has this year? What changed in the landscape? What changed in the national debate over immigration to bring what had been sort of a side argument of the whole matter to the forefront in this way?
Well, I think Angela made a great point. You know, people are frustrated, and rightly so. The immigration system is completely broken. It's very difficult to come in legally, and you know, you have great conservative thinkers, in my view, is like Milton Friedman, who told us that if you make the rule of law hard to follow, you will get more law breaking and thereby hurt the rule of law. But I want to hit on something else that Dan Stein said. Unfortunately, you know, as the only conservative here at this table, you know, I'll say this for our conservative listeners at home. You know, this notion that the Constitution is old and archaic and doesn't apply today, I think is a very misguided interpretation of the Constitution. The beauty of the Constitution is that its words are permanent, and that, you know, yes, we can amendment, but the First Amendment means what it says, the Second Amendment means what it says, the 10th Amendment means what it says, and the 14th Amendment means what it says. And you know, this notion that, you know, subject to the jurisdiction, right, that these folks who entered illegally didn't submit themselves to the jurisdiction. Well, whether or not they're in fact subject to the jurisdiction has no relevance it's not rooted in their own perception. It's rooted in actual fact. It's not, you know, just because you think that you're not subject to the jurisdiction doesn't make you not subject to the jurisdiction.
So merely being present, you're arguing, makes you subject to the jurisdiction.
Absolutely. Otherwise, the thing I've never understood by the proponents of people who want to misread the 14th Amendment is if you're not subject to the jurisdiction, how are you illegal, quote unquote, to begin with? I've yet to hear that explanation.
So this is a product of frustration, you're saying? Those who are upset about the current management of the comings and goings of people are bringing up birthright citizenship because of frustration over immigration overall?
I think so. I think people are rightly frustrated. There are a lot of problems, perceived problems, and other things that have come up. I think Arizona 1070 law is also a product of that frustration. People want to see solutions, and anything that even remotely appears as a solution, there are a lot of people who are willing to hop on those bandwagons just to address this very important issue, which we must address.
Diana, what do you think is going on here when something that a lot of Americans need explained to them up front before we can even have a conversation about it is suddenly presented for renegotiation?
Well, I think the situation is taking a small situation that is very extreme and trying to parlay that to be the norm.
What do you mean by that?
Well, Dan had mentioned, you know, having a group of, you know, foreigners come to the United States just to give birth. I mean, that's an extreme situation. That's not what this is about. This is about the Constitution that is sacrosanct. It is about the 14th Amendment that not only was critical to ensure equality for every person, but it also states that if you were born here, you become a citizen. And that's part of our Constitution. That is the fiber of the American system. And what you have here is you have a situation that because of some frustration of the immigration system being broken, they are instead working to change the Constitution and penalize children. This is in essence about children, and it's a law. I mean, any proposed change to this 14th Amendment of birthright citizenship really stands to just punish children.
Why? If you have deportable parents and they are deported, you go home with them, don't you? Wherever that may be, to the Philippines, to Mexico, to Honduras, wherever it is.
Generally. I mean, there are certain situations where, you know, family members, you know, end up having the children as well. There's also situations of where do the children go.
But why is that government punishment rather than an outcome of a situation set up by a child's own parents? Why is the government the bad guy for sending deportable parents home who are parents of citizen children, as opposed to the parents being the bad guy for creating this situation themselves in the first place?
And Ray, I also wanted to share with you, 48% of those individuals that are in the United States that are undocumented ended up coming unlawfully. Generally, the others, and the other 52%, they had their visas expired or various reasons. So I think we also have to focus on what the facts are.
So they came legally, but ended up remaining.
Yes, they
illegally.
overstayed their visa or they overstayed their lawful status. And I think the other important thing is this is a civil violation. This is not a criminal violation. So immigration violations are civil in nature.